Hi everyone, it's Luke here from the Blended Parent Network. I'm joined here by Anna today from JWK Solicitors in Lancaster, and we have got some questions that you guys have asked us on the Blended Parent Network Facebook page regarding family law. Anna works in the family law department here at JWK Solicitors, so we're just going to crack on. We've got quite a few questions to ask and just go from there. Right, first one, number one, what is parental responsibility and who has it?
Okay, parental responsibility means all the rights, responsibilities and duties that a parent has towards a child. A mother of a child will always have parental responsibility,
Okay.
and a father can acquire it in certain ways. The first and most common is for the father to be named on the child's birth certificate.
Okay.
So if parents are unmarried and the father is named on the child's birth certificate, and that child was born on after the 1st of December 2003, then the father will have parental responsibility.
Okay.
A father who's married to the mother will also automatically have parental responsibility.
Okay.
If you're in a situation where you're a father whose child was born before the 1st of December 2003, you're not married to the mother and it won't matter if you're named on the birth certificate, you won't have parental responsibility for the child. So in those circumstances, you can either get parental responsibility by entering into a parental responsibility agreement with mum or by an order of the court.
Okay, brilliant, thank you very much. Number two, what ages are children able to say for themselves if they want to go for visitation?
There's no set age for this, and the reason for that is because every child is different. So we could have a 13-year-old who is far less mature than an 11-year-old.
Yeah.
So there is no set age.
Okay.
If a court were being asked to decide, then what would happen is a body called CAFCAS would become involved.
Okay.
They're the Children and Family Courts Advice and Support Service, and they're social workers for the court.
Okay.
And what they would do is they would meet with the parents separately and possibly the child in some circumstances, and they will, as far as possible, determine the wishes and feelings of that child.
Okay.
And the court would then take that into consideration as part of a welfare checklist that they undertake, with the child's welfare being the paramount concern of the court. So in answer to the question, there is no set answer. It will depend on the child and how far their understanding can be assessed and whether the decision that they're making is influenced by a parent or whether it's their own decision.
Yes, got you. Brilliant, thank you. This one's quite a long one, so bear with me. It's a bit specific, but I'll try anyway. If a biological parent hasn't seen a child in years due to domestic violence, the last time they're seeing the child being when they were 7 months of age, and the partner has been in the child's life since the age of 7 months of age, the said child is in 4 months, calls him dad off her own back, as he loves, protects and does everything a dad should do, and she always known him as a first name from me. What will be the process of adoption for partner and child? Is there a specific length of time when you no longer have to ask a biological/abusive sperm donor?
Okay, what this question is asking is really about a step parent or an unmarried new partner who a child has considered dad from a very early age. Yes. The child's dad may not be in their life due to, in these circumstances, domestic violence. Yeah. And this is a very common situation. What the question is really asking about is adoption.
Yes,
and whether that's a process that the new partner or step parent could enter into. Adoption's quite a complex area, and it's a process which you probably need specific advice from somebody who specialises in adoption law. So adoption is somebody becoming a child's parent, in effect. They're assuming all of the responsibilities for the child. So really, in answer to this question, again, there's no set answer and there's no set period of time. Adoption is a process which is a long process that you would have to go through. There may be other alternatives that may be more attractive to adoption once you had opportunity to discuss those. So really, I would say in these circumstances, you need to seek some specialist advice.
Yeah, it's quite a complex issue, isn't it, adoption? Thank you for that one. I'd like to know where I stand legally for naming guardians for my kids. If something should happen to me, they all have their dads on their birth certificates, but there's no contact and hasn't been for years.
If there's a child arrangements order in force, which was formerly known as a residence order, depending on when it was granted, then if you have a child arrangements order in your favour, then any appointment of a guardian in a will take effect upon your death. So that would be the only way that you could make sure what you say will take effect if there is another parent with parental responsibility.
Brilliant. Thank you. Right, so next question. Got the order for the kids to live with me. Father isn't allowed to see the children due to domestic violence. Inform me that a court order runs out after 12 months. Am I right in saying no, it lasts until they are 16/18?
This depends on what order this person is talking about.
Okay.
Because there's domestic violence, or there has been in the past, it may be that she has what's called a non-molestation order, which is more commonly known as an injunction. Now, an injunction typically may only last for 12 months, so it may be that is being referred to here. Child arrangements order will generally run until a child is 16, 18 in exceptional circumstances. So probably what this person's referring to is she may have a non-molestation order which runs for a period of 12 months, but at the same time she may have got a child arrangements order for the children, because those two things often run together. What I would say is that this person should make an appointment with a solicitor. Take the orders that she has with them. Probably the solicitor who represented her previously, because they'll know more quickly than anybody else. And then a solicitor can look at the orders and give you the answer and tell you when they'll run until. They'll also be able to give advice about what steps you may need to take if you need to extend any of the orders at all.
Thank you. Right, this one's to do with mortgages. So, paid a mortgage on my own since 2013. My ex-partner still named on it, bracket struggling to remove him. He has quoted to me, when name is out of education, that house will be going up for sale. Can he make me sell even though he hasn't paid the mortgage since I kicked his bum out, running up debt behind my back and seeing someone else?
Okay. This is a complex area of law. He can't sell the property without her consent because she would need to cooperate with the sale.
Of course.
What he can do, however, if she does nothing and just won't agree to anything, selling the property or any other form of agreement, then he could make an application to the court under what's called the Trusts of Land and Appointment of Trustees Act 1996, which, because it's a mouthful, is shortened to TOLATA. So he could make an application under TOLATA to the court for an order that the property should be sold. That's something that should always be avoided, because in proceedings such as these, then there are risks involved as far as costs are concerned. An order could be made that you have to pay the other party's costs, and the order may ultimately be made. So the best thing to do in these circumstances is to try and reach an agreement now. This person's made reference in the question to being unable to get the mortgage side of things resolved. So even in those circumstances, which is a common thing, it would be better now to reach an agreement with the ex-partner, have it recorded into a deed of separation, which a solicitor can draft for you, which records exactly what's going to happen. It may be when the child is 18 or finishes education, but this is what's going to happen, X, Y, Z, so that everybody knows where they stand and you know what will happen in, say, another 10 years or 5, but you can reach an agreement between you. It saves the need for any contested court proceedings in the future and having that issue hanging over your head.
It can end up costing quite a lot of money.
The legal fees involved can be very significant, and that's just for your own fees if you're going to be represented. So it's much more cost effective to try and reach an agreement and to negotiate that than to end up in court proceedings, particularly because of the cost rules in those proceedings are generally that the loser pays the winner's costs. So you may also find yourself with the other party's legal bill as well as your own. Next question.
We are not married, so do I have any rights regarding what happens to our house? I think a lot of people have asked this one, so it's quite a big one for a lot of people.
When unmarried couples own properties together, as you say, this is a very big area and people are very uncertain. The reason I think that people are uncertain is because it's also a very complex area.
Yes, yeah.
And the rights of a party will depend on how the property is owned. So is it owned by one partner in their sole name?
Yes.
Or is it owned by both of them together, but still the ownership shares can vary.
Okay.
So if a property is owned in either the one partner's sole name or they're unsure about ownership shares, then there's no set answer, and what it will depend on, it includes various things such as what's recorded with the land registry as far as ownership is concerned, any other relevant documents or agreement that has been entered into between two people.
Yes.
If it's owned in one party's sole name, then the other party may have a claim against a share of the property, but that is a highly complex area of law, and what we would need to do in those circumstances is to look at the specific circumstances of how the parties have lived together, what financial arrangements have been between each other. Everything like that needs to be looked at in a case like this, and then what we'd be able to do would be to say, well, yes, it's possible you may have a claim against a share of this property, or not, as sometimes is the case.
Next question. Do I need to go to court to get a divorce?
Generally speaking, you won't need to attend court physically to get a divorce. The paperwork is sent to the court, who generally deal with it administratively. You'll only need to actually attend court if there's a dispute over the legal costs or the divorce is actually defended by the other party. That's a very uncommon situation, but there is a current case ongoing at the moment about a defended divorce, so it can happen, but largely speaking, no, you won't need to go to court.
Brilliant, thank you. And last question. How does family law work with different laws in Scotland and England? Now, we had this question asked 3 times, so there's obviously a few Scottish people that are part of the network, so yeah.
Okay. The question really answers the question here, because the laws in England and Scotland are different. So I can't advise on Scottish law, and the same applies on the reverse. So if you're in a situation, say for example, with property or marriage, if there are, say, assets in Scotland and England, it may be that you need to instruct solicitors in both areas, or that you instruct one solicitor to deal with things in the large part, but assistance still may need to be sought from a solicitor in the other jurisdiction to advise on a matter particularly relating to the asset in, say, Scotland.
Brilliant. Well, thank you very much. If you could just leave the video with a like and comment below if you've got any more questions. Thank you very much, Anna, for today. It's been very good. And yeah, any more questions, fire away. Thanks for watching. See you next time. Bye.